Good morning, beautiful people of West San Gabriel Valley Board of Realtors. How are you today? I would like to call this meeting to order. Thank you for joining us during our weekly hybrid MLS breakfast meetings. My name is CK, and I am your April program chair. Quick reminder, please silence your phone during the period of this whole meeting. What everyone has been waiting for. At this time, let me tell you a little bit about today's special guest, Jim Klinkert. Jim Klinkert is lead trial counsel for Klinkert, Gutierrez, and Neavel. Jim has tried cases involving as public and private constructions, employment title, contracts, escrow, business interference, partners and shareholder disputes, and many, many more. Jim graduated with honors from Loyola Law School in 1984 and began practicing law that same year. A former real estate broker, Jim has been active in organized real estate for more than 2 decades as an advisor to local realtors associations and a member of the California Association of Realtors Legal Affairs Forum. Outside the courtroom, Jim is an accomplished classical pianist. Now, without further ado, here is Jim.
We're all concerned about the antitrust settlement. We're going to be talking about that because that really affects the way all of us are going to do business moving forward. But that's not the only thing going on. So I got a short amount of time here this morning. I want to cover a few other things other than the antitrust litigation and settlement first. I'll go quickly through these things. One thing that's going on, you may have seen a notification from CAR about a week ago. There was a resolution between NAR and the Department of Justice back in 2020 having to do with some NAR rules about the basically clear cooperation policy and the participation rule. That was settled. Everybody thought it was behind them. The Department of Justice went up on appeal. They want to reopen their investigation. And the Court of Appeal ruled in their favor, allowing them opening the door for this investigation to continue. So in addition to the antitrust issues we're going to be talking about, we have another regulatory challenge to some of the NAR rules that's going to be coming up, and you'll be hearing more about that as the year goes on. Independent contractor status for agents. We all thought that was kind of resolved. There was a law a couple of years ago that called the Uber law that kind of settled things, we thought, and made it clear that if you've got a license, if the person has a license and there's a written contract and they're compensated for what they accomplish, not for the hours they worked, they're going to be an independent contractor for all purposes. There are some new Department of Labor regulations that just went into effect last month that kind of cast that into doubt again. The regulations go back to an earlier multi-factor test where it's not quite so clear who's an independent contractor and who isn't. And that hasn't been a problem for us in the industry for decades as far as federal tax purposes go, because the IRS gave up that fight decades ago, probably back in the 70s. But it's still sure. Okay. Thank you. It's still a potential issue when it comes to whether or not real estate salespeople are classified as employees for labor law purposes. And now we've got some gray areas out there. Once again, we may see some lawsuits by salespeople claiming that they are in fact employees entitled to all the benefits employees get, such as overtime laws, that type of thing. So watch out for that. There may be some more issues coming down the line as we get into the year with that. Rent control is again at the forefront. We had statewide rent control adopted a couple of years ago. There is a ballot initiative on the ballot for this fall called the Justice for Renters Act. And that essentially is an effort by initiative to overturn the Costa-Hawkins law. Costa-Hawkins was a statute back in the mid-90s that put the brakes on rent control. It established certain parameters and boundaries that local agencies and governments couldn't go beyond in terms of their rent control policies. If that passes, that protection for property owners and landlords, property providers, is going to be out the window. So keep an eye on that. You'll be hearing quite a bit more about that as we get closer to November. There's a whole laundry list of new laws. I'm going to touch on just a few of them very briefly because I want to get into the antitrust stuff. There is a new flipper disclosure law you may have heard about. It pretty much tracks the regular transfer disclosure statement, but it imposes some additional requirements such as identification and providing of contact information for the contractors who did the work prior to the flip. So if you're involved with flipping property in any way, and a flip is defined as a sale that occurs within 18 months after original acquisition. So if you're involved in flipping, make sure you're aware of that new enhancement to the disclosure requirements. There's a new law that puts a maximum time limit on a residential listing of 2 years. I was kind of surprised. I don't know what the need for that was. I don't know that I've ever seen a residential listing that was set up to last for 2 years. I don't know that there are many property owners who would agree to that. But apparently there must be some kind of an issue or problem out there, because this new law says you can cap it at 2 years. You can renew it once, but not for more than 1 year beyond that. There's a new law that provides a framework for remote notarization of documents. It's kind of interesting. I just started recording my documents about a year ago through a service that does it electronically, and found that pretty convenient. It might be nice to be able to get things notarized in the same manner. There's a new law that provides for separate conveyance of ADUs, basically as a condominium of the main unit. I don't know how that's going to work. I haven't seen that. I think it becomes effective in July. It'll be interesting to watch and see how that works. There's another new law having to do with ADUs that basically provides that local governments can't require owner occupancy of the ADU. So that kind of opens the door to more rental of ADU units, as opposed to just limiting them to use by the primary owner. There's a new law effective this year that limits tenant deposits to whether the unit is furnished or unfurnished to 1 month's rent. So that if you're a property manager or a property owner who rents property, keep that in mind. The criteria for no-fault evictions has been tightened up considerably. So again, if you're a landlord, keep that in mind. If you have somebody you need to evict, the rules may have changed a little bit and gotten a little bit more strict. In fact, most of the new laws on the books this year, they seem to either involve tenant rights or the need to provide additional housing for. As far as non-antitrust stuff goes, that's a few of the things that are going on. As you all know by now, there is a whole lot going on in the area of antitrust. And I want to take just a minute and go over briefly how we got here. Real estate by its nature is particularly susceptible to claims that the antitrust laws have been violated and that some anti-competitive conduct has occurred. And the reason for that is that an antitrust violation necessarily involves a conspiracy. One person acting by himself or herself can't violate the antitrust laws. They can't create a conspiracy. But real estate by its nature, it's tens of thousands, hundreds of thousands of agents cooperating together in an organized system to maximize the value of property for people. And that by its nature just lends itself to claims that there is a conspiracy to fix prices or engage in some kind of other anti-competitive activity. And we've seen that going back as far as probably 50 years ago. Back in the 70s, there were challenges to organized real estate based on the claim that commissions were fixed at 6%. And those claims were addressed, and it was made clear with all of our documentation that real estate commissions are negotiable, they're not fixed, and in practice, they're all over the place. So we had that over the decades that followed the 70s. There have been other kinds of challenges at various times. The one that got us into the pickle we're currently in and what we're dealing with, and I'm going to be talking about, was a series of challenges that basically, because of the way commission sharing is forced on sellers, sellers are disadvantaged and it's anti-competitive, and they have to pay more to sell their homes than they would if that system wasn't in place. And that claim showed up in several lawsuits, probably the most well-known and most important of which was by a lead plaintiff called Burnett. And that case went to trial in Missouri about 1.5 years ago. And it was a problem. And it was a problem because of some of the procedural rulings that the judge made down there. There's two ways an antitrust claim can be approached by a court. And the more restrictive and more dangerous view is treating it as a per se violation. If you're going to evaluate a plaintiff's claim of antitrust violation under a per se standard, you're looking at just facts in a vacuum. The judge is looking at, well, sellers have no choice but to split commissions or share commissions, pay a buyer's broker. I'm going to look at that. We're going to look at that. And that seems anti-competitive. The other way to approach these things, what most courts have typically done, is to look at the overall picture. Yes, if you look in a vacuum at the fact that sellers are being required to pay buyers' agents, that seems like it's unfair to sellers. But if you look at the whole picture, the fact is that under the system that existed, there are hundreds of thousands of agents out there competing to get the best possible price for a seller. And if you look at the overall picture in the grand scheme of things, that wasn't anti-competitive. It's actually a very competitive system of compensation and a very competitive system of conveyancing of property. But the judge made the determination he wasn't going to go in that direction, wasn't going to allow evidence of those compensating factors. The case went to trial and resulted in a huge jury verdict of 1.7 billion, I think the number was. And as a result, that spawned several dozens of what are known as copycat lawsuits. Every plaintiff's lawyer in the country that handled antitrust work wanted to cash in on this. Several copycat lawsuits were filed. There were 4 filed just in California alone. And while we were all scrambling around trying to line up insurance coverage, figure out who's on first, how these things are going to be defended, who's going to take the lead, lo and behold, a settlement was announced several weeks ago. And basically, the settlement, it's very far reaching. We don't know, the final details haven't been ironed out yet because, first of all, the settlement hasn't been finally negotiated. I've got a draft of it. It's about an inch thick. And it is still subject to some change. There's still negotiations going on. It's still subject to court approval, which hasn't occurred yet. So that could change things a bit. But there's basically 2 main components to the settlement. And one is that National Association of Realtors is going to pay a pretty eye-popping amount of money. It's 418 million in installments over 2 or 3 years' time. And that, in exchange, that's going to get NAR off the hook on these current claims. It's going to get California Association of Realtors and other state associations off the hook. And the settlement is going to also protect multiple listing services with organized real estate and most broker members of NAR. There are a few exclusions. Some of the really, really large brokerage firms are exempt from the money part of the deal. They are going to have to cut their own deals, but it's pretty broad protection. It will cover prior transactions all the way up to whenever the class settlement is noticed out, which is likely to be July. But so there's that part of it. That hopefully won't affect any of you economically very much. I imagine at some point, possibly your NAR dues may increase to cover that. I don't know if that's in the works or not. But the more important, the second part of this settlement that's been negotiated, and the one that's going to affect the way all of us do business, is there's a whole set of rules and policy changes that are mandated by this settlement. And basically, it comes down to it eliminates any organized form of commission sharing. No longer is it going to be possible to make an offer of compensation to a buyer's agent on the multiple listing service. That's going to be forbidden. And I've got a list of these things I'll go over with you basically as to what's allowed and what's not allowed. First of all, you can't have any offer of compensation to buyer's agent on an MLS. That's absolutely clear. You can't make an offer to compensate a buyer's agent on the multiple listing service. So there can't be a system in place that requires it, and you can't make that offer on the multiple listing service. As a result, multiple listing services are going to have to eliminate the broker compensation fields. And I know that CRMLS is hard at work on getting all their protocols in order. So is CLAW, the other big multiple listing service out on the west side of LA County. And the organized system, the multiple listing, cannot require participants in the multiple listing service to offer compensation. So basically, compensation goes away from multiple listing altogether. The part of this that's a little bit unknown and uncertain right now in my mind, there is also language in the settlement agreement that extends these prohibitions beyond just the multiple listing service platform. There is language that says parties who are protected by this settlement, which is all of you, plus local and state associations, and the National Association, cannot create, facilitate, or support any non-MLS mechanism that involves making of offers of compensation to buyer brokers. So we don't know how far that goes. Does that mean an individual brokerage firm can't put a notice on its website offering compensation? That's going to have to get played out and worked out, and we may get some clarification as we get closer to the effective dates of all these things. And by the way, this is going to happen real quickly, all of these changes. The settlement agreement language is as soon as possible. And generally, I think everybody's treating this as this all has to be in place by July at the very latest. The consequence, another rule is that any agent who is working with a buyer, before you open a home to that buyer, before you tour the home or make it available to them, you have to have a written agreement with that buyer. That's going to be a huge change in the way many of us do business. You no longer have the safety valve of knowing that if you find a buyer for something that's listed, because of the offer of compensation through the multiple listing service, you're eventually going to get paid. That's gone. You're going to have to negotiate that on a case-by-case basis, transaction by transaction basis. And there may be some issues enforcing that too that are going to arise as we work through all of these things. A member, a broker, or an agent cannot represent to a buyer that his or her services are free. Unless in fact they are absolutely free. If the buyer's agent expects to get compensation in any form from any source, that has to be disclosed. It can't be represented that you're not getting paid or that the buyer isn't going to have to pay you. Listing agents are going to have to disclose in writing and get their client's consent to any form of commission sharing with a buyer's agent. Forms that are used for transactions are going to have to clearly indicate that real estate commissions are not fixed in amount and they're freely negotiable by law. California Association of Realtors and all of us in California have been way ahead of that curve for many years. I don't know that any changes to our existing documents are going to be needed to satisfy that requirement. Interesting thing that hasn't been talked about much, but it's in the settlement agreement, is that if you're running, as an agent, you're running a computer search to find homes to show a prospective buyer, you can't limit that search to homes that pay a certain amount of compensation to buyer's agents. If you get caught doing that, that's going to be a violation of the settlement agreement and could subject you to liability. So you have to be completely compensation neutral in the way you go about finding homes for your buyers. The settlement agreement requires that NAR rescind or modify any existing rules that aren't consistent with the new policies. And NAR is going to be required, as our local associations, to come up with educational materials to help implement these changes. Now, what's not prevented by the settlement agreement? You can't have an offer of compensation. Offers of compensation off the MLS to a buyer's agent are generally okay, as long as it's not part of an organized platform that promotes those. So on a transaction by transaction basis, it's perfectly okay to negotiate that to get a seller to pay a buyer's agent's commission. And that can be done in the offered purchase. It can be done in advance by phone calls between the agents. As long as it's not accomplished on an organized platform that's essentially analogous to a multiple listing service, that's okay. It's also okay for sellers to offer concessions to buyers. So a buyer's agent can come in with an offer that says, yeah, we want you to pay the buyer's non-recurring closing costs. That's perfectly acceptable, as long as it's not tied to a requirement that a commission be. So basically, the bottom line to these changes is that commission sharing is gone as far as an organized framework goes. Any commission sharing that occurs is going to have to be an ad hoc type of thing that occurs from transaction to transaction. going to be implemented is going to be interesting to see over the next several weeks. I know NAR is hard at work now on changes to their policies, and what I understand is that they are going to be broadcasting those proposed new rules and policy changes in the very near future, probably this month, for comment from all NAR members. So we should see that. CAR and its attorneys are hard at work on not only education, so you're all aware of what can and can't be done under the new rules, but also on changing their standard forms. There's going to have to be changes to probably 6 or 8 or 10 standard forms or new forms developed to implement all of the new policies. And they're working on that. I had hoped to have a draft of those new standard forms before today, but it was delayed, and I'm told I might get them by this afternoon, which doesn't do us any good for us this morning. But anyway, they're coming, and you'll be seeing them real soon as well. CRMLS and its counterpart CLAW are hard at work on changing their policies and getting ready to implement the new rules as soon as they become effective. So you're probably going to see a lot from MLS as to what can and can't be done, how the formats are changed for input of information. I'm told is that CAR is working on a number of new forms or changes to forms. Those include a broker's compensation advisory form, which they expect to have out real soon, in the next 30 days or so. There's going to be a revised buyer's representation agreement that has a grid format similar to the RPA. There's going to be a revised residential listing agreement. There's going to be an open house agency agreement, maybe. I think that's still in the works. I don't know if that's going to occur or not. There was some substantial confusion about how the new policies and rules would relate to open houses. And I think the initial knee-jerk reaction was there's going to have to be a form that any buyer that's looking at an open house has to sign. But if you think about it, if it's somebody who isn't working with an agent and they are if it's just the listing agent for the property showing the property, listing agent has authority to show the property to anybody by virtue of the listing. So I think what was originally anticipated may be changed a little bit. There probably will be at least one new form having to do with open houses we'll be seeing. There's a couple of forms that are not going to be mandatory, but they're considered tools. One is a buyer identification of preferences and priorities, I'm told. And another one is a buyer financial personal information form. And then there's going to also be a disclosure and amendment for existing listing agreements, because when all these rules are finally effective, there's going to be a whole body of existing listings out there that won't comply one way or another. So there's going to be, CAR's going to come up with a form that brings those existing listing relationships into compliance, and they're going to do the same thing with buyer representation agreement. So anyway, I've got about 5 or a little bit more than 5 minutes left, and I wanted to allow some time for questions. So anyway, I'll stop there. Does anybody have any questions or any thoughts on all these things they'd like to talk about? Yeah, Vince. That's a problem. I mean, there's a real collision course here between fiduciary duties that all of you owe to your clients, whether they're buyers or sellers, and complying with the requirements of the antitrust settlement.
Hello.
So yeah, I don't know how that's going to get resolved and how it's going to be answered. You can follow your conscience on that. It is, and it doesn't have an easy answer. You're right. Yeah.
I'm sorry, if you have any questions, please come to the podium so the online guests can also hear you.
The new buyer broker agreement, is there going to be like a time period like a listing agreement has for a buyer? Like it begins on this date and ends on this date?
I think so, but I don't know for sure. And I think also there's going to be some other changes, I think, that from what we have right now, but I'm kind of hesitant to speculate about what those are going to be. I think they'll all be available to us very shortly. So probably should come back in a week and maybe we can have this discussion with more definition. Yeah.
Mr. Klinkert, how do you foresee the industry going with future potential buyer lawsuits? For example, you're my client, I show you a property, I'm not getting paid what I'm worth. I request it from the seller says no. I request it from you, you say, you know what, let's move on to another property. We go to another property, I sell you that property, I get compensated there. Fast forward, you and your wife are no longer happy with that home, and you come to me and say, you know what, Sylvia, I was a little pressured. We ended up going with a home we really didn't want to go with. Do you foresee that is a new wave coming in the future?
I hope it's not going to be a big wave, but I do see problems with that. Yes.
Yeah. And next, the way we have our listings currently right now in the MLS, is that going to be grandfathered, or are we going to have to remove the commissions effective mid of July once the DOJ makes that decision?
I'm sure those commission fields are going to be gone. I don't know what the mechanism for taking those out's going to be. I imagine CRMLS will probably just remove them automatically from all of them, because they would be in the soup under this settlement agreement if you have anything. Basically, MLS is removed from any kind of encouragement of commission negotiations under this settlement.
Sure. And what I'd like to share with you and my colleagues here is that the ugly and the uglier is already existing in the real estate practitioners that are not here and being informed. I've had 2 listings over the weekend where agents are knocking on the seller's door and going against the MLS guidelines on showing instructions. And I happened to be on a conference call when one agent knocked on her door and said, your agent's not returning my calls, and this is why I'm here. So I was
Wow.
on the phone with the seller. She was complaining on a conference call, complaining about somebody else knocking on her door. And I checked my log, and the agent called me literally 8 minutes ago. And I was on the phone, and I went off, and kind of just educated him. And you know what his response was? Do you want to show the ethics rule on me and you want to go that route, or you want to sell it, or what?
Wow.
Yeah, that's what's happening
No,
now.
I imagine there will be quite a spike in ethics complaints as a result of these rules, as everything gets worked out. Because NAR Code of Ethics continues in effect, and some of the new policies and rules seem to be in conflict with some of the provisions.
Well, thank you for being here. My question is, we have a few lenders,
Oh, can you talk to the mic?
friends. How is that going to afford for the buyer's affordability? Because as it is, if somebody goes FHA or VA with 3.5% and says, oh, now you're going to have to pay buyer's commission to the agent. And they're going to say, wait a minute, that's what, $4,000 for whatever the charges are. Obviously, that's going to have an impact on the buyer's perspective and the affordability. As it is, $1.4 million homes.
Yeah,
You
no,
know.
that's a legitimate concern. I've been told that it may not be as big an issue as you might think initially. I understand that Fannie Mae and Freddie Mac don't really look at closing costs being paid by somebody else in terms of their underwriting. I don't know if that's the case or not, but I guess, yeah, as far as a buyer's ability to qualify, if they're going to have to actually pay out of pocket to compensate their agent on a transaction, that could become an issue. I think that you also might see some response from the lending industry to help accommodate these situations. Something's going to have to give on some of these rules, I think. So.
Good. Very good. Yep. Thank you very much, Jim Klinkert, for your time. Now, on behalf of Western Gabriel Valley Realtors, we actually have a special gift for you. So, happy moments. It's gonna end sometime. So, before we end our meeting, quick reminder: please join our next week. Please join us next week for the MLS breakfast meeting as well at Thursday at 9 a.m. as we will welcome Alhambra Mayor Ross Maza. Are you sure? Alhambra Mayor? Wow. So come in next week, Thursday, 9 a.m., Alhambra Mayor Ross Maza. He will update us on the latest in the city of Alhambra, what's going on. Thank you everyone for joining our meeting today. Have a wonderful day. This meeting is now adjourned.